In this video, we are going to see the judicial control or review of administrative action. Let us start with the meaning of administrative action. Governmental authority has to perform three sorts of actions: administrative or executive, legislative or judicial. Sometimes there is overlapping of them. We are concerned here with the administrative action. Administrative action is the residuary action which is neither legislative nor judicial. Majority of the administrative action is statutory, means statute or constitution gives it a legal force, but in some cases it may be non-statutory, for example giving directions to the subordinates, etc. Non-statutory administrative actions have no force of law. Many times administrative action is confused with judicial action. Administrative action has no procedural obligations of collecting evidences or weighing arguments as in case of legal action. Administrative action is based on subjective satisfaction, where the decision is based on policy and expediency. It does not decide rights, but it may affect the rights. But then also we have to remember that principle of natural justice could not be completely ignored in case of administrative action. In A.K. Krapak vs. Union of India, the Honorable Supreme Court was of the view that in order to determine whether the action of the administrative authority is quasi-judicial or administrative, one has to see the nature of power, to whom the power is given, the framework within which the power is conferred, and the consequences of it. Now let us see the meaning of judicial control or judicial review. Judicial review deals with the legislative, administrative as well as judicial action. We are dealing here with the administrative actions. In one sentence, we may define judicial control as the ultimate authority of the court to restrain the exercise of absolute and arbitrary power. The doctrine of judicial review has been originated and developed by American Supreme Court, although there is no express provision in American Constitution for the judicial review. In Marbury vs. Madison, the Supreme Court made it clear that it had power of judicial review. Also in Keshwanand Bharti vs. State of Kerala, it was held that judicial review is the basic structure of the Indian Constitution. As far as administrative action is concerned, the court scrutinizes the act for determining the issues as to whether it is within the scope of the authority or the power conferred on the authority exercising that power. Now let us move to the grounds of the judicial control or judicial review of administrative actions. These grounds can be enlisted as judicial error or ultra-vireness, error apparent on the face of record, violation of principle of natural justice, unreasonableness or irrationality, improportional, legitimate expectations, etc. Various grounds of judicial review were developed by Lord Diplock in the English case Council of Civil Service Unions versus Minister of Civil Service. Now let us discuss these grounds one by one. First ground is jurisdictional error, which is also called as ultra-vires. Normally, the term jurisdiction means power to decide. The ground of jurisdictional error is based on the principle that administrative authorities must correctly understand the law and limit that authority before any action is taken. When there is lack of jurisdiction, excess of jurisdiction or abuse of jurisdiction, such act is termed as ultra-vires act or there is jurisdictional error. Such act may be declared void by the court. In one case, R versus Minister of Transport, the minister had no power to revoke the license. The order of the minister revoking the license was thus held to be passed without jurisdiction and hence held ultra-vires. Next ground is error apparent on the face of record. An error is said to be apparent on the face of record if it is ascertained merely by examining the record and without consideration of other relevant material. Violation of the principle of natural justice is one of the important grounds to invalidate the administrative action. Here both the sides and no bias are two main principles of the natural justice. Any action of administrative authority can be considered as unreasonable or irrational if it is against the logic or accepted norms of the moral standard that no prudent or sensible man on the given facts and circumstances could act or arrive at such decision. We can take the example of Nehajan versus University of Delhi case where the cancellation of the examination and debarring the student from next exam for adopting unfair means in the examination was held disproportionate punishment, it was substituted by cancellation of only one paper as sufficient punishment, since the basic requirement of Article 14 is the fairness in the action of the state. Next ground is improportional. Proportionality means the administrative action should not be more drastic than it ought to be for obtaining desired result. Proportionality is sometimes explained by the expression taking a sledgehammer to crack a nut. Sometimes this ground is taken similar to that of unreasonableness or irrationality. As an example, we may see in the construction versus workmen case, where some workers remain absent from the duty treating a particular day as holiday, they were dismissed from the service. The industrial tribunal set aside the order as the punishment was not only severe but out of the proportion. Next ground is legitimate expectations. A legitimate expectation amounts to an expectation of receiving some benefit or privilege to which the individual has no right. It means expectation having some reasonable basis. A legitimate expectation arises in the mind of the complainant where he has been led to understand by the words or actions of the decision maker that certain procedure will be followed in reading a decision. A doctrine of legitimate expectation has been evolved to give relief to the people when they are not able to justify their claims on the basis of law in strict sense, but they suffered civil consequences because their legitimate expectation has been violated. Now let us conclude our discussion. Judiciary has given a wide power for controlling the administrative actions, and if we see the various grounds of judicial control, then we can conveniently group them under three categories: constitutional grounds, statutory grounds, and ordinary or equitable grounds.